putting my on which I want to lead today. Okay, now you have my full attention again. Welcome. I'm recording the class. Ms. Ashipala, your mic is on. If you can just switch off your mic. Okay, thanks. Okay, welcome. I looked at the course outline in preparation for the class, and it seems that when I set up the course schedule, I was obviously not focusing properly, because the past 2 weeks we've been having to go so fast, and we've really been pushing to get through everything. And then I noticed this week we only need to do Unit 8. And Unit 8 is really not very long. It's 3.5 pages. So not very much. So I'm going to finish Unit 8 tonight. It won't take us long. It's fairly straightforward as well. And then on Wednesday, I'm going to start with Unit 9. Not going to leave the whole of Unit 9 for next week. It's always better to be slightly ahead. And then, so next week is Unit 9. The week after is a revision week, and you are writing your first test. Your first test is face-to-face. You will be writing during class time on the Wednesday, starting at 5:30 in the basement, as well as, no, not in the basement, sorry, I'm lying to you, in Auditorium South, as well as the test will also be available at all the regional centers. So Wednesday evening during class time, you'll be writing your test. Although all your classes are online, your first test is face-to-face. You have to write at least one face-to-face test so that you can also get the feel of what it is like to write face-to-face, how I set up my tests, etc., etc. So we're moving on then to purchase and sale. What we've done so far is the general principles of the law of contract. The requirements for a contract to be valid. Look briefly at the contents of contracts, terms of a contract. Then we looked at what happens if things go wrong, breach of contract and the remedies. And then we looked at how contracts come to an end. For the rest of the semester, we are looking at special contracts, specific types of contracts. Now, just to sort of explain, wait, let me upload then, or share my screen. Then I can actually also type while I'm explaining this. It might make a bit more sense. Okay, just confirm to me quickly. Can you see my screen? It's the document that I've been using to teach, where I type my lecture notes. Thank you, Rushay. Mitchell, Heiko. Okay, obviously everybody can see the screen. So just to put you in the picture, we did the general law of contracts. These basic principles that we looked at, the 5 requirements, always, they apply to each and every contract. It does not matter whether this is a contract of purchase and sale, whether it's a lease agreement, whether it's a contract of agency, or whether it is a partnership. You might not realize this, but in a couple of weeks' time, when we start doing partnerships, you will learn that a partnership is, in fact, just a contract, a contractual agreement between a number, 2 or more people that decide to work together. So the law of partnerships falls squarely under what we are doing in the semester in this particular course. So what we learned in the past 2 weeks about the general principles of the law of contract. The fact that we're moving on to purchase and sale now doesn't mean you can tick that off and forget about it. Because all those rules, unaltered, apply to purchase and sale. There can be no purchase and sale if the contract isn't valid. In fact, most of my examples that I used while I was teaching the general law of contract, I used the example of selling a cell phone. So I actually used the contract of purchase and sale to illustrate the concept of requirements for a valid contract, breach of contract, termination, etc., etc. It's important to be able to classify a contract. So you get different types of contracts. And it's important to classify. It's important to be able to classify your contract. Not all contracts fall in a particular type, a particular class, but purchase and sale, for example, it's important to be able to classify, to identify a contract as purchase and sale. Why? Why is it important? Because different types of contracts have different legal consequences. Certain types of contracts have legal consequences. We spoke about implied terms. If a contract is a particular type of contract, there are certain implied terms, that will always apply. Unless the parties specifically, expressly So if it's a contract of purchase and sale, because it's purchase and sale, there are certain natural legal consequences that attach to purchase and sale that do, for example, not attach to a lease agreement or a donation. So as a starting point, it's important to know this contract that you are dealing with. Is it purchase and sale, or is it perhaps something else? If it's purchase and sale, there are implied terms that will always apply unless the parties agree expressly to exclude them. Just an example, we'll be doing this. This is in Unit 9, so we're going to get back to this. But a contract of purchase and sale, for example, comes with an implied warranty. You know what a warranty is? Warranty, guarantee, same thing. A guarantee against latent defects. But if you want to sell the thing as is, so I'm selling my cell phone to Heiko, and I don't want him to come back afterwards and say, but it doesn't charge properly or whatever. Heiko and I can agree that it's sold as is. And then he gives up his right to claim against me based on the guarantee against latent defects. But if we have not expressly decided to exclude this guarantee, it will apply. Unwritten, it's there, implied by law. It's a natural legal consequence. So when Heiko buys my phone, he doesn't have to ask me, is it working properly? I don't have to say to him, I guarantee it for 6 months or whatever. Because that comes with the contract purely because it is purchase and sale. Guarantee against latent defects doesn't necessarily apply if it's a donation. If I gave it to him as a gift and it doesn't work properly, he can't come back and say, no, but you must pay to have it fixed. It's a defect or an implied contractual term which attaches because it is purchase and sale. So what is a contract of purchase and sale? In order to know whether a contract fits into this little box, so to speak, you need to know what a contract of purchase and sale is. So the definition that we have here in the notes is it's a mutual contract. So there's always two parties involved. Can't sell something to yourself. Mutual contract for the transfer of possession of a thing in exchange for payment of a purchase price. Another definition is it's an agreement in terms of which one person to deliver a thing and the latter undertakes to pay the Now, from this definition, first of all, there's something that stands out that you probably don't know or don't realize. So I'm going to teach you something right now. Purchase and sale relates to the transfer of possession. One person undertakes to deliver a thing. These definitions do not refer to ownership. There's a difference. Between ownership and delivery. And it's important that you grasp that already right now. And I'm pretty sure you don't know this. And I need to tell you right away, if you're listening to me now, think with your heads. Don't think with your hearts. Because if I tell you that passing of ownership does not necessarily follow from a purchase contract of purchase and sale. You can buy something and not become the owner. Obviously, when you set out to buy something, you want to become the owner. That's why you buy it. But sometimes the law's a bit different and you buy it and you don't become the owner. This is discussed in a lot more detail in Unit 9, so I don't want to elaborate on that too much. But except to tell you right now, and now you're all going to be horrified and tell me I'm lying, but I'm not lying. That cell phone that Heiko bought from me, if I had originally stolen the cell phone from Ruche and I sell it to Heiko, it is still a valid contract of purchase and sale. You do not need to be the owner of the thing sold in order to enter into a valid contract of purchase and sale. And this is very important. It's very important that the law works this way, because as you learned previously, these remedies that you get to protect you, you only have remedies if the contract is valid. If that contract was void, Heiko wouldn't be able to claim anything from me. In order for Heiko to have remedies, because I can legally, validly sell a stolen thing, that doesn't mean that the law leaves him without protection. That we'll get to in Unit 9. But he would not have protection if the contract was not valid. So I know this might be difficult for you to get your heads around, that you can actually buy something and end up not becoming the owner. Think with your heads, not with your hearts. It will become more clear as we go on. So, transfer of possession, a contract for the delivery of the thing, not a contract for transfer of ownership. Okay, so when do we have a valid contract of purchase and sale? Firstly, in order for us to have a valid contract of purchase and sale, the contract itself must be valid. So those 5 requirements must have been met. You cannot have a valid contract of purchase and sale if the contract itself is not valid. Then, in order to put this contract in the box called purchase and sale, there are 3 further requirements. There must be the agreement to buy and sell. That's fairly straightforward. There must be an agreement on the thing sold. You don't need to know the Latin, but the Latin term is in the notes, but you can quite happily, I'll be quite satisfied if you just say the thing. You don't have to say the max. And there must be agreement on the purchase price. If the contract is valid, but there was no agreement on a purchase price, it remains a valid contract, but it falls in a different box. It's not purchase and sale. Just want to scroll up quickly. as I said, I will share these notes with you. This contract, this question, I refer to it as structured application. I've said, is there a valid contract? I can switch it up. Valid contract of purchase and sale. So you will definitely in test one get structured application, but there's a variety. It could be anything. It can be, is there a valid contract? Can be, is there consensus? Can be, is there contract of purchase and sale? In order to check whether it's a valid contract of purchase and sale, firstly, you check, is your contract valid? And then you'll check, is there an agreement to buy and sell? Is there a thing? Is there a purchase price? We already had the answer for that particular example that I put up there, but can you remember? So if I change the question, is it a valid contract of purchase and sale? What is your answer going to be? Come, somebody. Heiko, what is your answer going to be? Is there a valid contract of purchase and sale or not?
According to me, it's a valid contract of purchase.
Read carefully. Read carefully. Contract
Okay,
must be valid.
it is invalid due to the age of the buyer.
Yeah, absolutely. People, when you read your questions, read every single word. It is heartbreaking, and I've come across it in all my years of teaching. I've come across it so often that people who actually know their work and understand the work get answers wrong because they were rushing and they didn't read the question carefully. Heiko totally understands everything I've said to now. He just didn't read properly. She's only 16 years old. Contract is not valid because she doesn't have contractual capacity. So watch out for that, especially when you get to multiple choice. My multiple choice questions are complicated. You have to read very carefully. So let this be a lesson to all of you now, to always never jump into the answer too quickly. Read carefully. Okay, so let's just briefly then look at these. We've done contract must be valid. I'm not going to go over that again. We've done that. So firstly, it must be the agreement to buy and sell. There's nothing complicated about this. It's pretty much similar to there must be consensus, agreement to buy and sell. Only thing I can point out here is that the court will give effect to the of the parties. So not to what you call the contract. Sometimes because there's stamp duties and stuff payable to certain contracts. A contract of donation, for example, has stamp duty payable. So people sometimes try to disguise their true intentions by calling the contract something else. Yes, Heiko?
The question, however, if it should be now an invalid product or the seller didn't obtain it on a honest manner and he sells it to you, meaning um, you, the buyer now, are set in a more neutral position, if I may ask.
Um, I wouldn't say a more neutral position. The buyer, the law actually protects the buyer. And we'll do this in more detail in Unit 9. It's
Okay,
called
perfect.
it's called the guarantee against eviction. If
All right.
you, yeah, if you have bought, if I sold you the cell phone that I stole from Ruche, she
Yes,
can come and I can't, you don't become the owner of it because I wasn't the owner. Which means Ruche can claim it back from you. But
yes,
the law protects you in those circumstances. It gives you certain rights of action against me so that you don't end up having paid me without getting a phone.
perfect.
But that,
Thank you very
we do that in more detail in Unit 9.
much. Thank you.
Okay, so there must be the intention, the agreement to buy and sell. The court will give effect to the true intentions of the parties. So if we want to disguise our agreement, and instead of agreeing with Haiku that he will buy the phone, we agree that I will give him the phone and he will give me money. So we call it donations. The court will recognize that as purchase and sale, irrespective of what we chose to call it. But that doesn't happen that often. That's not, um, don't break your heads over that. So let's look at the thing. You can sell contract of purchase and sale. There must be a thing. The thing must be definite and ascertainable. You need to be able to identify this thing. So if I agree with Haiku that I will sell him something for $1,000, that's not a valid contract of purchase and sale. It's not saying it's not a valid contract. Let's say I agree with Haiku that he can come to my house and select anything for $1,000. I'll give you a moment now, Haiku. That is still a valid contract, but it is not purchase and sale because anything for $1,000 isn't the thing sold isn't identified. Haiku, you had your hand up?
The question is, so it must be specified precisely. Yeah, I can take your life, basically. It sounds very rude, but regarding the statement, $1,000 for anything.
Yeah, if it's $1,000 for anything, then we haven't specified the thing. You don't always, and for your purposes, we don't in commercial or 1A, for example, that the marketing and business management and whatever students do, We go into this in more detail. You only need to know the detail which is in the notes. There are um, different types of manners in which the thing can be decided. So definite, make it all
Maybe
ascertainable.
if I may
Or,
ask,
yes, I go.
sorry for the interview, intervention.
No, no.
If somebody goes broke, say, and he says, well, you can take whatever you like for X amount. It's also part of a contract if you take it now in the way like this. Then it's most probably a certain or not a certain there.
Yeah, my example was perhaps not entirely clear because, in fact, I think coming to think of it now, my example that I gave was actually incorrect because it must be specified or ascertainable. So if a company has gone bankrupt, for example, and the agreement is that you can come and select 6 items from the warehouse for $1,000. That will be a valid contract of purchase and sale because it's described. You don't have to say things A, B, C, and D, as long as it is narrowed down. So 6 things from the warehouse. It is ascertainable. You can find out what it is. Or you can go to a shop that's a place, a business that sells building sand, and you buy 20 kilograms of sand. It's not a specific 20 kilograms. There's a big pile and it's 20 kilograms from that pile. But 20 kilograms of sand is sufficiently describing it to make it ascertainable. Is everybody with me? So it must be definite or ascertainable. This I've already said. Seller does not have to be the owner. However, you cannot buy your own stuff. Cannot buy things that already belong to you. Has to belong to somebody else. Otherwise, it can be anything. It can be movable, immovable, corporeal. You can even buy future things. What do I mean by that? Let's say I have a dog, and I enter into a
Ma'am,
contract. Yes, yes, Rushay.
please check the lobby. There are people that want to join the class.
Where must I? Okay, let me chat quickly. Okay, just give me a second. Let me just sort this out. I did share the link. We just share it again. Please remember that the classes or the lectures are recorded. Students that have problems joining the class, I will share the recording. Okay, where was I? Future things. I was going to give an example of this. Let's say I have a dog and I enter into an agreement with Candy that she will buy a puppy for $500. That will be, even though this puppy has not yet been born, the thing is sufficiently identifiable. I'll read your question now, Pamwe. The thing is sufficiently identifiable, one of the puppies to be born from my dog, to make it, even though the puppy does not yet exist, it will be a contract of purchase and sale. Pamwe has asked here regarding future sale, is a pre-order also a contract of purchase and sale? It absolutely is, because the thing is identified. If your favorite author or artist is going to be releasing a new album on a particular date, and you pre-order this album, it is identified, this album to be released. So yes, it is, a pre-order is absolutely a valid contract of purchase and sale. Let me just get back to my notes. With regard to future things, what happens if the thing does not into existence? Or, in fact, if we thought that this thing exists, what do you think? What will happen? What will the effect on the contract be? Heiko, your hand is up.
Well, regarding this issue, with a future aspect, then the contract will be cancelled, and if there are any deposits were made, it must be refunded immediately, like a estate or whatsoever.
The final consequence will be the same, but the contract will not be cancelled. Let's go back right to the start. So I know it sometimes gets confusing perhaps sometimes, because yes, if there any money had already been paid, it will be refunded. There you are absolutely correct. But it's not correct to say that the contract will be cancelled. You can only cancel a contract if you actually have a contract. What is a contract of purchase and sale? Work with me here. One person undertakes to deliver a thing. Now, if it doesn't exist, you cannot deliver it. So is performance possible? Come work with me, Heiko.
No, it isn't impossible. It isn't impossible. Not at all.
Exactly.
Because there isn't anything which can be obtained regarding this. It's a future object still.
Yes, but if it doesn't come into existence, or even at the time when you enter into the contract, let's say I agreed with Apollonia that she will buy my horse that's on the farm on Gubabas. Not just
Yes.
any horse, a specific horse. But what we don't know when we enter into this contract is that the horse died last night.
Yeah.
So I cannot deliver this horse.
Yes.
Is performance possible?
No, it isn't possible. And there must, yeah, according then to the groups in the contract or to the parties, then an addendum needs to be made or whatsoever regarding this issue.
No, you don't need to make any addendums or anything. We're going back
Oh,
to the absolute basics here.
okay.
5 requirements for a valid contract. Performance must be possible. If performance is not possible, is there a contract?
No.
There's no contract.
Okay.
If delivery is not possible because the thing doesn't exist anymore, or it never was supposed to come into existence, but then it didn't come into existence, delivery is not possible. If
Yeah.
performance is impossible, your contract is void.
So back to basics then.
Back to basics. There's nothing to cancel. You can only cancel a valid contract.
Precisely.
At the end of the day, Heiko, and I can understand why it seems confusing to you, because at the end of the day, the end result is actually the same. If you had already paid me, I have to give you your money back. And we both back where we started.
Yes.
So the final conclusion is actually, the final result is actually the same. But it is important for the purpose of studying law that you distinguish between a contract that is void, that is a nothingness,
Yes.
and a contract that for some reason had to be cancelled.
Yes.
And
I totally.
I'm telling you now, Heiko, and everybody else, it's good that Heiko has raised this. And please, people, do not be shy to discuss with me and ask questions. Even if you get something slightly wrong or whatever, it gives me the opportunity to take this and make sure to explain it again and make sure that everybody understands. It's very good that Heiko just asked this. I'm literally, or said this, because I'm literally going to ask this in test 1. Did I type it out? I'm going to ask this in test 1. If the horse is dead at the time or before the time of contracting, there's no contract. Performance isn't possible. If, however, the horse was alive, but when she goes and fetches it a week later, it has since died, our contract will terminate. Because then, at the time of contracting, delivery was possible. But when it had to happen, it was no longer. The difference between objective impossibility of performance, contract is void. Supervening impossibility of performance, the contract will terminate. Is everybody with me? Okay, so Roche is asking here, ma'am, what if we agreed on a black horse in the contract, the black horse died? But we change agreement and the person settles for a white horse. Is the contract still valid since performance is possible? We did this. If we then decide, okay, not the black horse, but rather the white horse, what are we talking about here? Novation. Our original contract will, depending on when the horse died, whether the horse died, was already dead when we contracted or dies afterwards, it's going to be either the contract is void or the contract will terminate, and then we agree on a white horse. That is an entirely new, our first contract has terminated. The agreement for a white horse is an entirely new contract, novation. And you are always, Roche, welcome between two parties that agree to enter into a new contract. The law isn't going to say, no, you originally agreed on the black horse, so under no circumstances may you now buy a white horse. Horse law absolutely allows you to now get a white horse, but it's a new contract. Justy, your hand is also up.
Yes, ma'am. Can you please explain to me the difference between the objective impossibility of performance at the time of contracting and supervening impossibility of performance after contracting? I didn't get that part. Sorry.
It depends on when. Let me just go back to that. Depends on when, the time when performance is impossible. If performance is impossible at the time of contracting, when we reach consensus, it's objective impossibility of performance and the contract is void. If the contract is valid, so the performance was possible when we agreed, but then at a later stage, after contracting, but before performance. Contracting, but before performance. The contract is valid, and a valid contract, and I've said this many times, a valid contract doesn't suddenly become void. Once it's valid, but then it comes to an end, it terminates. So that's where the difference lies in the time. Was it impossible to perform already at the time of contracting, or at the time of contracting it was possible, but afterwards something happened and you can no longer perform? Okay, is everybody now more comfortable? Yeah. Is everybody now more comfortable with this? Okay, then the purchase price. Once again, similar to the price must be agreed upon. It must be definite or ascertainable. Definite, $100, $200, $300. Ascertainable, I want that whole pile of sand at $100 a kilogram. You still first have to weigh the sand to find out how many kilograms there is, but then you can calculate the price. So that isn't particularly complicated. You can agree that a third party will determine the price. So if we agree that Haiku will buy my cell phone at a price determined by Rushay, that is valid. An agreement, however, that Haiku will buy my cell phone for any amount that he wants, not valid. So we must either agree or it can be an outside third party, but one of the contractual parties cannot, after agreement, randomly indicate the price. That makes sense. Wouldn't work if I agree with Haiku that, okay, you can buy my cell phone. He agrees to buy my cell phone. I'll tell him, I say to him, I'll tell you what it costs next week. And then I tell him suddenly out of the blue, I want 20,000 for it. And he's bound to that because he agreed whatever amount I charge. Your common sense should tell you that the law will not allow something like that. And then the last aspect of the price must be predominantly money. So an agreement between me and Apollonia that she will buy my cell phone, and instead of paying me, she will look after my children for a week. It's a valid contract, but it's not purchase and sale. There must be a purchase price. It can be money and goods, but the larger part must be money. It must be an amount. So she can buy my cell phone for $500 and 3 bags of apples. Haiku?
Just out of interest sake now regarding to this, if I would give a monetary value, say servicing your vehicles and maintaining your house or whatsoever for this price, would that be ascertainable or not?
Be careful. A monetary amount for servicing my car, that's not purchase and sale. You're not getting possession of the car. You're not taking delivery of the car. You're only working on the car. It's a valid contract, but it's not purchase and sale.
Yes, I understand. But the question now is you want to sell me the cell phone. I say, good, I'm going to service your car for, say, $800, and I'm going to fix your doors in your house. The price is there, $200 altogether. It's yeah, say 1,000 or whatsoever.
Okay.
Would this work or not?
Okay, I understand what you mean. I understand what you mean. If we merely agreed that you will get the cell phone in exchange for servicing my car, that is not purchase and sale. I do think if we agreed that the value of servicing my car is $200, that's actually then two separate agreements. There's the contract of purchase and sale that you're buying my cell phone for $200. Then we have a separate agreement that instead of paying me the $200, you will service my car.
All right.
Do you follow? Do you follow? You follow what I'm saying?
Perfect. 100%. Thank you.
Yeah. But just to say, cell phone servicing car, not purchase and sale. It's then rather an exchange agreement or whatever. Can't always stick a name to a contract, but that will not be purchase and sale.
Thank you very much.
Okay, so that then is the 3 requirements for a contract of purchase and sale. There must be an agreement to buy and sell, there must be a thing, and there must be a purchase price. Then the last paragraph of this unit relates to conditional contracts. I don't really have to say anything about this. In fact, I'm not going to say anything about this. I just brought this into this unit because the concept of conditional contracts becomes relevant in Unit 9 again when we do the passing of the risk rule. So you need to know, we did terms of a contract and we learned what a condition is. Contracts of purchase and sale are contracts. So they can be subject to either a suspensive condition or resolutive condition. Don't need to teach you, this is literally a repetition of what we did in our last class. So you can go back to the notes there. When we did termination of we did not termination, what am I talking about? Terms of a contract, resolutive conditions, and suspensive conditions. There we use borrowing the umbrella, but the whole concept also applies to contracts of purchase and sale. Let's change this. Evelina can buy my umbrella if her mother gives her the money. So the uncertain event here is whether her mother is going to give her the money or not. If her mother doesn't doesn't give her the money, the whole thing lapses and the contract terminates. So that is a resolutive condition. Sorry, ignore everything I've just said. I wasn't thinking now. That is, in fact, a suspensive condition. My bad. Suspensive condition. Performance will only start if the uncertain future event happens. So, not borrow, we want purchase and sale here. Evelina can buy my umbrella. So we've agreed that there will be purchase and sale. If the uncertain future event doesn't happen, there will be no performance. I don't need to deliver the umbrella. Resolutive condition, Evelina can buy my umbrella if she does not pay at the end of the month. I can take the umbrella back. So there was performance, I have delivered, but if this payment at the end of the month does not happen, the contract will terminate, it will come to an end. So that is the same as what we have done previously. It does become relevant again. So I just wanted to bring it into this particular study unit. It becomes relevant again in Unit 9 when we do the passing of the risk rule. Okay, any questions? I thought this was going to be a short lecture, only 3 pages, but there were lots of discussions and questions. Thank you so much for that. It has enabled me to explain, make sure that you thoroughly grasp everything rather than just glossing over things. Always ask your questions. I do appreciate that. Don't be shy. Don't think that if you make a mistake or you didn't quite understand something, you will be embarrassed or I will embarrass you. I will never do that. If you make mistakes, it gives me the opportunity to clarify this issue. Because if Haiku didn't understand something, chances are Rana, Multra, Dushay, and Justy also didn't understand that. I need to know that you didn't understand so that I can clarify it. Okay, thank you so much. I will see you then on
Thank you,
Wednesday.
ma'am.
Oh, Haiku's got his hand up again. Yes, Haiku.
I'm sorry, it's now when the class is done now. I just want to ask the test. It's basically now the 3rd week from now on. Next week and the week after it, and then thereafter we write the test, if I'm
Yes,
correct.
the Wednesday. So there's basically 2.5 weeks. We've got this week and next week still for class. And then the week after that, the Monday session, we have a revision session, and then you write on Wednesday.
Do we have got a date plus minus? Because I do not have it now in the head. I just have to check up on the, yeah, otherwise I check up on the.
Yeah, I don't have my course. It's the last week in March. I don't have the exact date with me now. I don't have my course
100%.
outline ready
No
with
stress.
next to me.
Thank you very much.
Okay.
Bye.
Okay. Anybody else? If not, then I'm going to say goodbye to you.
Goodbye, ma'am.
Bye-bye. I'll see you on Wednesday.